So friends, are you ready? Ready to see the evidence of the crimes Donald Trump committed on and around January 6th to try to steal a presidential election? Me too. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, I was in court in D.C. yesterday in Donald Trump's election subversion case, and I want to start today with the main and most important issue that was discussed, debated, litigated, and resolved by Judge Chutkan. And then I want us to go to the transcript of yesterday's hearing and look at a strange and remarkable discussion regarding two things. One, quote, that Florida judge, close quote, apparently whose name shall not be mentioned in court. And two, everybody's least favorite and most corrupt Supreme Court Justice, Clarence Thomas. But let's start with the new reporting. This from the Washington Post. Headline, Judge, U.S. can lay out Trump election interference evidence this month. And that article begins, a federal judge called Thursday for prosecutors and defense attorneys to file significant legal briefs in Donald Trump's 2020 election subversion case before voters head to the ballot box in November, rejecting the former president's request to move at a slower pace. Let me translate that. Donald Trump's lawyers asking to move at a slower pace. Donald Trump's lawyer in court yesterday over and over again begged, pleaded with the judge, don't let the prosecutors disclose any evidence of Donald Trump's January 6th crimes before the election. Move at a slower pace? They want to keep that deeply damaging evidence buried, hidden, secreted from the American people, from the American voters, before we all have to go to the polls. Yeah, a slower pace. The article continues. After a testy one-hour hearing in federal court in D.C., U.S. District Judge Tanya Chutkan granted a proposal by Special Counsel Jack Smith's office to make its case about the limits of Trump's immunity by September 26th, with other filings due in the weeks that follow. Her, Judge Chutkan's, scheduling order offers the first glimpse into how the case will proceed after the Supreme Court ruled that presidents cannot be prosecuted for their official conduct, upending the Trump prosecution and forcing special counsel to seek a superseding indictment. Chutkan's decision gives the government, the prosecutors, an opportunity to lay out new evidence against Trump, though how much, if at all, they will choose to reveal in the run-up to the election remains to be seen. In court, Trump defense attorney John Lauro had sparred with Chutkan over the schedule, arguing that the next 2 months is a very sensitive time before Republican nominee Trump faces the Democratic nominee, Vice President Kamala Harris, at the polls. This quote from Judge Chutkan, quote, it strikes me that what you're trying to do is affect the presentation of evidence in this case in a way so as to not impinge on the election of a president, Chutkan told Lauro after the Trump lawyer objected to an order that would let prosecutors make their case first. Quote, this court is not concerned with the electoral schedule. So friends, Judge Chutkan rejected Trump's lawyers' attempts to keep all this evidence hidden from public view until after the election, which had nothing to do with the litigation of the issues in this case. You know, This was a political argument from Trump's lawyers masquerading as a legal argument, and Judge Chutkan saw right through it and rejected it. And then, after the hearing, Judge Chutkan issued a 2-page scheduling order, and there's really only one line in the scheduling order that we need to focus on. The government, the prosecutors, shall file an opening brief on presidential immunity by September 26, 2024. And that opening brief, which will be filed on September 26th, will lay out all of Donald Trump's crimes and acts. And the brief will argue that those crimes, those acts, are not official presidential duties or conduct. They were the acts of a candidate, and frankly, a criminal, desperate to disregard the expressed will of the voters and unlawfully retain the power of the presidency. And those acts are not entitled to immunity. Donald Trump can and must be prosecuted for those crimes. Okay, friends, let's finish up with what was a really bizarre exchange between Judge Chutkan and Trump's lead criminal defense attorney, John Lauro, regarding that Florida judge. We all know they were talking about Judge Aileen Cannon, but apparently nobody was willing to utter her name in open court yesterday. But they talked about Judge Cannon and her ruling regarding special counsel. We'll get there in a minute. And then Supreme Court Justice Clarence Thomas made an appearance in yesterday's hearing. So let me set this up before we look at just a brief portion of the transcript from yesterday's hearing. Every court in the land, including the Supreme Court, that has ruled on the issue of whether special counsel is actually a thing, is lawful, is constitutional, every court has ruled, yeah, special counsel is lawful, including the Supreme Court years ago, including the D.C. Federal Circuit Court of Appeals, and importantly, that's the appeals court in D.C. that sits atop the trial courts in D.C., like Judge Tanya Chutkan. She is duty-bound to apply that controlling precedent from her appeals court, saying special counsel is a thing, it's lawful. So she's bound by that. And the Supreme Court ruled that way as well. But enter that Florida judge, Judge Aileen Cannon, who, after Clarence Thomas wrote a little note in a separate concurring opinion in the presidential immunity case saying, I don't think special counsel's a thing. Hey, psst, Judge Cannon, why don't you throw the case out on that basis? That's not exactly what he said, but that sure was the message Clarence Thomas communicated. And mind you, a little judicial doodle like that, a separate concurring opinion in a case that otherwise has nothing to do with whether special counsel is lawful, is not precedent. It's not a thing. It's nothing. It's judicial nonsense by a compromised Supreme Court justice. So against that backdrop, let's turn to yesterday's transcript to see how it is that Florida court judge and Clarence Thomas made appearances in the discussion in yesterday's Trump case. Trump's lawyer, John Lauro, says the following to Judge Chutkan. Justice Thomas wrote a very persuasive concurrence that suggested that the special counsel does not have authority. And in addition, another judge, a very respected judge in the Southern District of Florida, wrote a decision dismissing the special counsel's case on appointments clause basis and also on appropriations. And it is a critical issue that now has to be decided by the court in light of Justice Thomas's interest in the issue and also in light of what the judge decided in the Southern District of Florida. So apparently Judge Aileen Cannon is now like Voldemort, she whose name shall not be mentioned. Well, Judge Chutkan does away with John Laurow's arguments about special counsel pretty quickly. So you have dicta, meaning non-binding ruminations of a judge. You have dicta in a concurrence written by Justice Thomas, and you have an opinion filed by another district judge in another circuit, which frankly, this court doesn't find particularly persuasive. But apparently undeterred that Judge Chutkan is having none of this ridiculous argument about special counsel, Trump's lawyer then makes this remarkable statement. Justice Thomas, in effect, directed us to raise this issue and suggested that we do it immediately in light of his view in that concurrence. And I can tell you, friends, I think everybody in the courtroom was taken aback by that statement, by that representation by Trump's lawyers, including, it seems, Judge Chutkan. Because here's what she said in response to Trump's lawyer saying that a Supreme Court justice directed them to raise the issue and suggested that they do it immediately. Judge Chutkan said, "He directed you to do that?" And then Trump's lawyer begins the backtrack. Well, I shouldn't say he absolutely said, do it, but when you read that opinion, it's absolutely clear that that's something that we have to do now to preserve the issue. And Judge Chutkan says, well, I certainly don't read the opinion that way. Well, friends, I would sure like to know if Supreme Court Justice Clarence Thomas, quote, directed Donald Trump's lawyers to raise the issue and, quote, suggested they do it immediately. Because if he did, that would be improper, unethical, conspiratorial even. And, I know everybody would be shocked to find that Supreme Court Justice Clarence Thomas did something improper, unethical, or conspiratorial. Well, friends, stay tuned, because on September 26th, at long last, we will see at least some, if not most, of the evidence of Donald Trump's crimes on and around January 6th to try to unlawfully retain the power of the presidency. Yes, that's right. The American people, the voters, will get to see for themselves what Donald Trump did. And that is pretty darn important as we approach another presidential election. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.